Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour, and yes, that's right, folks. We're back. We're back with the Truth Attack. Okay, so I got a lot of information I want to try and get into today's show, so let's just get right into it. We are the Liberty Works Radio Network, and we do need the support of the members of the listening audience to keep the network operating and the broadcast coming. So if you enjoy the show, the information, the lectures, the topics, and the other shows on the network, we sure would appreciate it if you could find your way over to the Liberty Works Radio Network.com website and get signed up as a monthly subscribing member. Even if it's as little as $10, $20 a month, every membership helps, and we do need your support to keep the network operating. And if you want to get fully informed on the maladministration of the federal income tax, which is destroying this country by being the basis of the class warfare system and has the population waging war on itself amongst the different classes that are literally defined by the brackets of the income tax system, and which allow the politicians to constantly usurp more power as they're constantly invoked by all classes on every side to intervene in the class warfare and exercise more power to settle the warfare that they engineered with the class divisions set in law, thus destroying the constitutional requirement to tax uniformly and to treat the American people uniformly with equal rights, equal access, equal opportunity, and equal protection under the law to every person, and not certain protections for some and none at all for others who will be persecuted and attacked endlessly. So it all begins and ends with the classes of the tax brackets in the income tax system. If you want to get informed on what's gone wrong and how, you need to go over to Tax-Freedom and start reading, or pick yourself up a copy of The Simple Truth About Income Tax for just $4 at irszoom.com, or get yourself the whole manual, The American Tax Bible, for $50 at irszoom.com. And if you know anyone who needs help answering letters from the IRS, a lien, a levy, a summons, any letter they've received, send them to irszoom.com, refer them to us. We answer letters from the IRS for $30, $40, or $50 a letter with no other payment required. And we're the only people in the country that help you answer the IRS with law. So that's irszoom.com, taxfreedom.com, and the Liberty Works Radio Network. And I've also put up a new YouTube channel recently, Thomas Freed. You can link to it from the taxfreedom.com website. That's tax-freedom. And I've been doing lots of videos on the news of the day, the bottom line, and videos exposing the fraudulent application of the income tax, which I'm going to try and get to tonight, since we've been doing so much current events continuously for the show for the last couple of months. So let's get into it. Freedom comes from God, folks, not government. The truth shall make you free, for God is the truth, and God's true plan for mankind is freedom derived from faith in God, not government, or man, or any other institution or philosophy. You place your faith in anything other than God, it will be used against you to betray you and enslave you to the institution, man, philosophy, or government in which you misplaced your faith. And that's the history of government of mankind. They lie to you, steal your faith, and use it to enslave you, which is where we're headed today under this income tax system, which is not a tax system at all. It's a system of peonage debt service that compels the American people to a system of involuntary servitude to pay the debts of the Congress owed to the Federal Reserve Bank. And that's why you have a $35 trillion debt and growing. So the system is rapidly wiping out middle-class America, particularly with this Federal Reserve Bank chairman in place who refuses to lower interest rates. Switzerland actually lowered rates today. First country to do it, first central bank. Apparently, they're the only money men in the planet that understand what's going on and are working to restore access to capital for Main Street. Of course, it would be the Swiss bankers, right? Of course. So, what do we got in the news? Well, it's hard to understand, but the Democrats and Joe Biden have betrayed the American people. They simply have decided to take up defending the criminals, the illegal aliens, the murderers, the undocumented, instead of helping Americans. It's simply mind-boggling. They're defending the criminals and protecting them. They're defending the illegal aliens. They're helping the cartels by playing the coyote for the second half of the leg. The cartels deliver the children to them at the border, and ICE delivers them to the prostitution rings in Chicago, New York, LA, and San Francisco. They're taking the side of the squatters all over the country against the homeowners. They're refusing to charge for assault and battery. They're not prosecuting the cartel members smuggling the kids in. They're assisting them. They didn't prosecute any of the Black Lives Matter, the violence, the looters, the protesters. They have taken the side of the criminals and the criminal element on every single one of these things. And what are they doing? That's right, they're prosecuting Catholics who object to abortion. They're prosecuting the parents of students who object to transgender dysmorphia in the schools and critical race theory, racism being taught to their children. They're prosecuting protesters at the Capitol, but not the violent protesters, only the ones who peacefully walked through the Capitol on January 6th. And of course, they never prosecute the Democrat criminals. Hillary got away with colluding with Russia, lying, destroying evidence, and committing classified document crimes, as did Joe Biden. The Democrats don't get prosecuted. But any Republican or conservative, they are the enemy. So Democrats and Biden have taken up against America. They're treating you like the enemy while they're ushering in the foreign presence and spending the budget on the foreigners instead of the veterans or the Americans. It's absolutely disgusting. It's absolutely sick. You could argue it amounts to treason. It's definitely sedition, because every single one of his policies is, as a matter of policy, a violation of law. Starting with not enforcing the border and ending up with delivering the children to the sex traffickers in the cities, where they're immediately registered to vote, given a green card, and sent to work, which is the next story. I was going to suggest the American people might want to consider boycotting Tyson Foods and Tyson Chicken, because they've decided to fire Americans in order to hire illegal aliens out of New York. Now, I don't know what would drive a company to make that sort of decision, but they've made it, they're doing it, and America should stop buying Tyson Foods products because of it. Boycott the company, boycott the brand. Send them a message. You want to hire illegal aliens instead of citizens? Fine. See how much of your chicken they buy. So, and of course, the angry old man is out on the campaign trail yelling and screaming about Donald Trump at every opportunity. But go ahead, ask him about his policies. He doesn't remember. The only thing he can do about his policies and his own actions is lie. Lie about them and deny. Deny he took money from China. Deny he's in business with Hunter. Deny, deny, deny. The man's a pathological liar. He never should have been elected. I told you 4 years ago, he's the most corrupt, most racist politician on Capitol Hill, and that if you elected him, you would be sorry. And if that's not the case today, you died a couple of years ago and are no longer alive. So, we've got an angry old man who gets lost on the stage every time he goes out there, whose staff won't allow him to take any questions. I think he's a coward. He's afraid to face reporters. He's afraid to answer questions. He's afraid to confront the American people. He's afraid to discuss his policy. He's afraid of Russia. He's afraid of Iran. He's afraid of Hamas. He's afraid of so many things. He's paralyzed. He sits there and watches Afghanistan deteriorate into a crisis. Haiti deteriorate into a crisis. Russia, Ukraine deteriorate into a crisis. Hamas, Israel deteriorate into a crisis. And he picks the wrong side on every single one of them, except maybe the Ukrainian-Russian conflict. Just mind-boggling. And of course, as I said before, he blew that by not helping the Ukrainians defend their border before Russian attacked. When the enemy masses troops on your border and you don't put defenses on the border to discourage it, you're inviting them in. They lost that on day one, before day one, when they refused to help Ukraine oppose the buildup on the border, which was the only thing you could have done to stop the invasion. Stop it before it began. Okay, well, Riley Gaines is suing the NCAA under Title IX. It sure took long enough. She and a number of female athletes who have been cheated out of honest competition and who have watched the NCAA and the colleges and the competition committees violate Title IX by letting men compete in women's sports, dominate, and take home the trophies and championships and the scholarships. Title IX was implemented in 1970s. In 1970s, the original intent of Congress in passing the legislation was to protect women in certain spaces, not men who were mentally confused and thought or felt they were women, but women, biological women. And what that means is that this is a pretty easy case to win. You go in under Title IX, arguing original intent, and biological science is the determining factor in whether or not someone's allowed to compete in a women's competition. Biological science. XX, you're in. XY, you violated the law, and you're liable for the damages done by the violation. So this is a simple case, and if the NCAA and the schools don't settle, they're going to get reamed in front of a jury. They're going to get reamed on original intent, which didn't include men, and biological science, which excludes men specifically by biological fact. So, well, what do we got here? Okay, just a couple more things. Fannie Willis should have been tossed. The fact that the judge didn't throw her out along with Nathan Wade proves he's not a judge. He's not a lawyer. He's a political animal. And surprise, oh, he has an election in 2 weeks and a candidate just announced. So he was put in the position of an election coming up in 2 weeks in a blue, very blue demographic, where if he didn't let Fannie Willis stay on the case, if he threw both Wade and Willis off, essentially letting Donald Trump walk, the blue demographic would have tossed him out of his judgeship immediately. So he found a decision to throw Wade off and keep Willis on. So he thinks by walking that middle ground, he can persuade the blue voters to put him back in office. And it's as dirty as it gets. It's politicizing justice, and you're openly politicizing actions from the bench. It's just as corrupt and dirty as it gets. And more evidence that this case is a complete and total fraud. It's being made up to interfere with the election to the extent possible by discrediting Donald Trump at every level and every turn in the hopes that it will somehow make him less appealing to the general population, who is finding him more and more appealing every day as the Democrats turn to defending foreigners and criminals instead of citizens. Okay, I think I hear the music coming on here, so we're going to be coming up with the first commercial break for 5 minutes. We'll be back after the break. And again, if you want to get fully informed, find your way over to taxfreedom.com or irszoom.com and get signed up at the LibertyWorksRadioNetwork.com website. We'll be back in 5 minutes. Okay, this is Thomas Freed on the Liberty Works Radio Network. This is the Truth Attack Hour. And I'm going to change topics here. Like I said, I've been talking about current events for almost a month now without getting into the income tax. And I want to go over some points of law coming out of the Donald Trump tax law change in January 2018. I wrote an article then, The Broken Tax System. It's posted on the tax-freedom.com website, taxfreedom.com, if you're interested. And the article exposes how the tax change in the law enacted under Donald Trump on January 1 of 2018, it became effective. That tax change gutted the IRS and DOJ's ability to lawfully enforce income tax in the federal courts using the arguments they've been using for 60 years. So, this information, these excerpts from that article. So let's just kick right in. Congress has no idea of what they have done or of the true extent or size of the catastrophe within the tax enforcement system that they have potentially wrought with the new income tax law. And few Americans, if any, have realized it yet. Still today, that's true. But any honest lawyer will tell you, after reading this, that everything you are about to hear or read and have read up to this point in this article is irrefutably true. Fact. For the last 60 years, the IRS has been issuing income tax collection correspondence to Americans, asserting that American citizens owe the payment of an income tax on their work because of the adoption of the 16th Amendment. This claim to legal authority under the amendment is all over their website. It is in their frivolous arguments, publications, and documents, where they repeatedly assert that the income taxing authority is granted under the 16th Amendment and label as frivolous any reference made to limitations on the taxing powers imposed under Article 1 of the Constitution, or any claim that it is not a direct tax under the amendment, is also labeled as frivolous. And those are the pleadings that are made by the government on the record of the court as a plaintiff in every tax case prosecuted in the federal courts in the last 50 to 60 years. Fact. The Department of Justice attorneys argue in every single income tax case prosecuted in the federal courts that the income tax is owed by the individual defendant as a function of the 16th Amendment alone, without use or need of any applicability of authority under the constitutionally authorized indirect Article 1, Section 8, Clause 1 taxing powers to tax by impost, duty, and excise. Fact. For the last 60 years, the federal courts have been wrongfully and erroneously allowing and upholding the constitutionally prohibited and therefore unconstitutional direct taxation of the alleged income of the American people, where the income is created as a function of their labors and the exercise of the right to work, and where the tax is allegedly imposed as a direct tax without apportionment or any other limitation under alleged authority conferred under the 16th Amendment to tax. So they're alleging the 16th Amendment is the source of all authority, and they don't use Article 1, impost, duty, and excise. Fact. The 16th Amendment has no enabling enforcement clause in it that would constitutionally authorize the U.S. Congress to write any new law, to enforce any new power allegedly newly created or authorized under authority of the amendment alone. So without the enabling enforcement clause, there can be no law. But if there isn't any law authorized, how would a court take subject matter jurisdiction, since they only have jurisdiction to enforce authorized law? But none is authorized under the amendment. So you've kicked the stool out from underneath yourself as a federal court, claiming it's the 16th Amendment. Okay, there's a power granted. Let's assume that's right. Where's the authority to write law to enforce that power? No enabling enforcement clause, no authority to write law, no authority to write law, no subject matter jurisdiction for the court, because it needs an authorized law to enforce that specific taxing power, i.e. the new power to tax directly and without apportionment. You can't get that from here, not without becoming a communist and practicing the second plank of the Communist Manifesto in place of constitutional taxation, i.e. a heavy progressive or graduated income tax. That's where you find graduated taxation in the Communist Manifesto. That's where you find income tax is a direct tax, is in the Communist Manifesto. It isn't in the 16th Amendment. Fact. There are amendments to the Constitution both before and after the 16th Amendment, which do have and clearly do contain an enabling enforcement clause of their own within the amendment, irrefutably proving that the absence of an enabling enforcement clause in the 16th Amendment and the absence of any such alleged grant of any new enforceable power is intentional by Congress, the authors of the amendment. Fact. In assessing the legal effect of the 16th Amendment in 1916, the Supreme Court plainly said that the 16th Amendment conferred no new power of taxation. Here's a quote from Stanton v. Baltic Mining, one of the original deciding decisions handed down in 1916. This is actually a decision handed down right after Brushaber. This decision, Stanton v. Baltic Mining and Brushaber v. Union Pacific, are the two controlling Supreme Court decisions on the nature of the federal income tax. Here's what the court wrote. The provisions of the 16th Amendment conferred no new power of taxation, but simply prohibited the previous complete and plenary power of income taxation possessed by Congress from the beginning from being taken out of the category of indirect taxation to which it inherently belonged. So the court is telling you the 16th Amendment doesn't create a new power. It can't. First, it doesn't contain the word direct. Second, there's no authority to write law under an enabling enforcement clause. So no law can be written. So it couldn't possibly confer a new power that was enforceable. Well, what they're really telling you is that it's not a new power, it's part of the indirect powers. This has always been part of the indirect powers, where income is not the object of the tax or even the subject of taxation. It's the yardstick that measures the amount of tax that is owed on the earnings derived from the taxable activity. The taxable activity being activity subject to some impost, duty, or excise, where impost tax is foreign activity, duty tax is exported goods, and excise tax is commodities, licenses, and corporations. None of the powers that are made enforceable touch the labors of the American people with legal effect as a tax. They tax the labors of the non-resident alien under Section 1441 and the original income tax legislation of the Underwood-Simmons Tariff Act of October 3rd, 1913. It was a tax collected from non-resident aliens and foreign corporations. Never been imposed on American citizens. It's imposed on taxable income. And the taxable income is the income of those persons subject to the collection of the tax by the withholding agent, the tax collector, who is the actual taxpayer, not the individuals who work. It's the tax collector who has the legal duty to pay the tax to the Treasury and has the legal duty to interact with the Treasury with respect to the payment of tax. And he's liable for everything he's collected. But when he pays tax, he never pays tax out of his own pocket. He only turns over what is taken from other people. So it's an indirect system. There's a shifting of the burden of the tax. The collector is the taxpayer, but he doesn't pay tax out of his own pocket. He turns over what he's collected from other people by withholding. And they adopted this exact same scheme 32 years later in 1945 when they adopted the employment tax laws of Subtitle C and made the employer the collector who withholds from employees who allow it and ask for it on a W-4, and then it's the employer who's made liable as the collector from the payment of the tax that he has collected from his employees. Now, the employer has an additional half of the tax that he has to pay on Social Security and FUTA, but those are taxes imposed on the corporate privilege, not the employee's allegedly gross income or taxable income or sources. So, fact. The Article 1, Section 8, Clause 1 authorities to tax allow taxation only indirectly by uniform impost, duty, and excise, and do not reach the labors of the American people with legal effect as a tax. This is why the federal government has argued for 60 years that it's the 16th Amendment that authorizes the tax and is the sole basis for the enforcement of the income tax imposed by Section 1 of Title 26 United States Code. That's the income tax. In speaking of the Article 1 taxing powers to tax by duties, imposts, and excises, the Supreme Court has consistently said, now this is all quoted from the court, we think that they were used comprehensively to cover customs and excise duties imposed on importation, consumption, manufacture, and sale of certain commodities, privileges, particular business transactions, vocations, occupations, and the like. Duties and imposts are terms commonly applied to levies made by governments on the importation or exportation of commodities. Excises are taxes laid upon the manufacture, sale, or consumption of commodities within the country, upon licenses to pursue certain occupations, and upon corporate privileges. They cite Cooley, Constitutional Limitations, 7th edition. The tax under consideration, they continue, as we have construed the statute, may be described as an excise upon the particular privilege of doing business in a corporate capacity, i.e., with the advantages which arise from corporate or quasi-corporate organization, or when applied to insurance companies for doing the business of such companies. As was said in the Thomas case, 192 U.S. Supra, the requirement to pay such taxes involves the exercise of privilege, and the element of absolute and unavoidable demand is lacking. If business is not done in the manner described in the statute, no tax is payable. If we are correct in holding that this is an excise, there is nothing in the Constitution requiring such taxes to be apportioned according to population. And it cites Pacific Insurance Company v. Sewell, Springer v. United States, Spreckle Sugar Refining Company versus McLean, Flint v. Stone Tracy, and Thomas v. United States as the authority for that declaration. It goes on. Excises are taxes laid upon the manufacture, sale, or consumption of commodities within the country, upon licenses to pursue certain occupations, and upon corporate privileges. The requirement to pay such taxes involves the exercise of the privilege, and if business is not done in the manner described, no tax is payable. It is the privilege which is the subject of the tax, and not the mere buying, selling, or handling of goods. This is from Flint v. Stone Tracy, 220 U.S. 107, 1911, 2 years before the income tax amendment was passed, the 16th Amendment in 1913. This is from Flint v. Stone Tracy in 1911. And this is mirrored in Black's Law Dictionary and in the lines of precedential of authority that have been cited by the Supreme Court. Excise taxes are taxes laid upon the manufacture, sale, or consumption of commodities within the country, upon licenses to pursue certain occupations, and upon corporate privileges. Flint v. Stone Tracy, 220 U.S. 107, or a tax on privileges, syntax, privilege tax, Black's Law Dictionary, 6th edition. So Black's Law reflects the definition given by the Supreme Court directly. Again, the subject matter of taxation, if the tax is a direct one, it shall be apportioned according to the census or enumeration. If it is a duty, impost, or excise, it shall be uniform throughout the United States. Together, these classes include every form of tax appropriate to sovereignty. It cites Bruce Shaber versus Union Pacific and Stewart Machine Company versus Collector. So we see the Supreme Court has been absolutely consistent in the limit of reach of taxing power created by the Article 1 impost, duty, and excise taxing powers. And they've never ruled the 16th Amendment created a new power, which is what the federal government has been arguing in the lower courts, who are in rebellion against the Supreme Court, the Constitution, and the concept of a limited government. We'll be back in 5. Okay, this is Thomas Freed on the Liberty Works Radio Network, and let's get right into it. I got one more section here I want to read from the Supreme Court in 1937 that addresses this, and again, this is some 24 years after the adoption of the income tax. It's probably a good bet the Supreme Court had it all nailed down by then, so let's listen to what they said. Whether the tax is to be classified as an excise is in truth not of critical importance. If not that, it is an impost, citing Pollock v. Farmers Loan and Trust and Pacific Insurance Company v. Sobel. Or a duty, citing VZ Bank v. Fenno, Pollock v. Farmers Loan and Trust, and Knowlton v. Moore. It goes on. A capitation or other direct tax? It certainly is not. It's from Stewart Machine Company v. Collector, 301 U.S. 548, 1937 is the site. So 24 years after the income tax, it's not a direct tax. It's an excise, an impost, or a duty. And they cite all the cases that establish that historical application of the income tax as part of the indirect taxing powers to measure the amount of tax owed on the income earned from the impost, duty, or excise taxable activity, and no others. No others. Imports, exports in foreign places, commodities, articles of commerce, licenses like to sell ATF, and those are the commodities subject to tax along with petroleum fuels, and the corporate privilege, where labor is conducted by right, not privilege. The earnings derived by right aren't subject to taxation by impost, duty, or excise, and that's why they've had to argue it's the 16th Amendment, but there's no authority to write law under the amendment. The whole thing's been a fraud for 75 years, a complete and total fraud. So let's go on. So, in the 1930s, when the Supreme Court handed down this ruling, the labor unions saw what was coming. They're going to try and tax the labor of the unions. So they lobbied Congress and they passed Title 15, United States Code Section 17. Now remember, the Supreme Court says excise taxes are taxes on articles of commerce and commodities and the corporate privilege. And they were afraid that they would try to tax the labor of the unions, the wages of the labor unions, under the excise powers. And impost, since impost only taxes foreign activity and duty taxes exports, neither of those powers could ever be alleged to reach labor, so it had to be excise. And the unions saw what was coming. They lobbied and they got past Title 15, United States Code Section 17, which plainly and clearly states the labor of a human being is not a commodity or article of commerce. Oh, they had a law passed to remove the labor of the union personnel from excise taxation because it taxes commodities and articles of commerce, and it specifically says the labor of a human being is not a commodity. So under the U.S. Constitution, this law removes the labor of a human being, American citizens specifically, from subjectivity to any and all taxation by excise under Article 1, Section 8. So you can't get there by impost unless you're in a foreign country under tax treaty or in a territory or possession. You can't get there by duty because it only taxes exported goods, duty-free shops at the international airport terminals. And you can't get there by excise. Commodities, articles of commerce, licenses, and privileges. And most occupations of common law don't require a license or a corporate privilege. They're conducted by right, and rights aren't taxable, neither the possession of the right nor the exercise of it after the fact. You can go right to Harper v. Virginia Board of Elections in 1964 to see that the right to vote can't be taxed, not even $1.50. Not even $1.50. Can't tax the right to vote. If you can't tax the right to vote, you can't tax the right to work. Because at the same time you were litigating the right to vote in 1964 through 1966, you were also protecting the right to work, weren't you? And it's not just the right to work of the black population, it's the right to work of the American people, which makes it immune to taxation by the federal government. And the government admits Article 1 doesn't get there. Doesn't get you to the taxation. That's why they've argued the 16th Amendment. But that brings into question the issue of the subject matter jurisdiction of the court to enforce the claims engineered under the operational practice of the IRS, claiming authority to tax directly and without limitation all earnings as though it were taxable income, even though they're not listed in gross income. And the only salaries and wages actually taxed by law are the salaries and wages of the non-resident alien, where they are taxed in Section 1441B of Title 26. They're not there in Section 61. Salaries and wages aren't listed. They are listed along with compensation in 1441B. You got three separate distinct sources of compensation where earned by a non-resident alien, and two of those sources, salaries and wages, are removed from subjectivity under Section 61. Yeah, they just waited for a judge to use judicial legislation to alter the law and declare salaries and wages were a form of compensation. So now everything you do is taxable and you're all slaves because I altered the statute to make it a direct tax on all labor instead of an indirect tax on the compensation earned by a corporation or a person working in Canada under the tax treaty, which is where Section 61 originated. Section 61 did not originate as part of the original income tax legislation in 1913. It wasn't part of the original Underwood-Simmons Tariff Act. It came 5 years later in 1918 as part of the Canadian Tax Treaty, and it had limited applicability to persons, Americans, in Canada working under the treaty. And that lasted for 75 years and expired in 1993. Section 61 has been dead letter law for 30 years. It's on the books, but the original legislation expired, and when original legislation expires, all the statutes enacted with the original legislation also expire unless they were reenacted in the interim by Congress with a greater applicability than they had in the original legislation. That's never happened. The only applicability Section 61 had originally was to the Canadian Tax Treaty. The only applicability that's been added since then is its applicability under other tax treaties with other countries, mostly in Europe. Now, how does subject matter jurisdiction get taken by the federal courts when no law is authorized to be written under the 16th Amendment? And it's absolutely required to show that Congress was constitutionally authorized to write law in order for the court to have a law that it can take jurisdiction under to enforce something against an American citizen. Without the authority to write law in the amendment, there can be no new laws that are authorized to enforce any allegedly new power. That means the courts have been acting without subject matter jurisdiction for 75 years. This is a criminal conspiracy of the highest order, of treason, sedition, and betrayal of the American people to enslave them to a never-ending trillion-dollar debt owed to a private corporation, which is where all the money's going. None of it goes in the Treasury. None of it. Nothing taken from your paycheck, none of the collected tax, none of the money sent in on April, none of it goes in the Treasury. It all goes to the Federal Reserve Bank to enslave the American people, to convince the bank to continue lending to Congress. The three required elements of our constitutional law in America necessary to establish the subject matter jurisdiction of the court that can be allegedly taken over any legal action in order to establish that jurisdiction can be taken. It is necessary for the plaintiff or the court itself to identify, one, a specific taxing power that is granted by the Constitution or an amendment for Congress to exercise in operational practice. An example, Article 1, Section 8, Clause 1, impost, duty, and excise. 3 powers granted, the limitation is uniformity. So there's an example of powers granted. 2, second leg of subject matter jurisdiction. Second required element, the third leg of the second leg of the three-legged platform that creates the standing for the plaintiff in the court. To ask the court to help him enforce the claims based on these authorized laws. The first leg is a taxing power granted by the Constitution. Got to identify what it is. Impost, duty, excise, something else. Tell me, what is it? Where is it? 2, the second leg, a specific grant of authority for Congress to write law must be made by the Constitution or amendment with respect to the administration and enforcement of the specific power granted in number 1. And this authority to write law is conferred by the original Constitution under Article 1, Section 8, Clause 18, the original necessary and proper enabling enforcement clause that gives Congress authority to write law for all of the powers granted by the original body of the Constitution, but which provides no authority to write law under any succeeding amendment, each of which must have their own enabling enforcement clause in order to be enforceable at law, because Congress was authorized by the amendment to write law. We see that in the 13th Amendment, banning involuntary servitude and slavery. We see it in the 14th Amendment, guaranteeing the civil rights of the freed slaves. We see it in the 15th Amendment, guaranteeing freed slaves the right to vote. We don't see it in the 16th Amendment because no new power was intended to be created. It's clarifying the use of income as part of the indirect powers. It's not creating a new power. The 17th Amendment was administrative. It provides for the election of the senators by general election rather than appointment by the state legislatures, which was how it was done under the original Constitution. Senators were the state's representative in the three-house system or the three-branch system. So the 18th Amendment is prohibition. There's an enabling enforcement clause there for both the federal and the states. The 19th is the suffragette, the women's vote. There's an enabling enforcement clause there. The 23rd, the 24th, the 26th. All these amendments after the 16th have their own clause, and therefore it's impossible to argue that the 16th Amendment set a precedent where it was no longer necessary to have an enabling enforcement clause. Without the enabling enforcement clause, the courts can't take subject matter jurisdiction under the 16th Amendment. The whole thing's a fraud. The third element of subject matter jurisdiction is Congress being authorized to exercise a power and authorized to enforce it with law. Congress has to write a law that does that. So you have to have a power granted, an authority to write law, and then Congress has to have written the law. So since the 16th Amendment doesn't contain the word direct, you can't show me a direct power that's granted. Since there's no enabling enforcement clause in the 16th Amendment, you can't show me an authority to write law to enforce any alleged new power allegedly created under the amendment. And since they wrote the Underwood-Simmons Tariff Act, which is one form of an impost, you can't show me a direct tax piece of legislation that Congress ever wrote. They wrote a tariff. They wrote an impost. They didn't write a direct tax law. They wrote a tariff collected at the source from foreign persons. And the Supreme Court specifically recognizes and points out this scheme of indirect taxation of collection at the source in its Bruchaber decision upholding the constitutionality of taxing indirectly by collection. And what they don't talk about and have never taught, but it's still right there in the law, plain as day, that there's no collection of the tax from citizens, only non-resident aliens who are subject to the tariff, the impost. And citizens are not subject to it. So we're coming up on the end of the show. I think next week I'll try and talk more about that Bruchaber decision where they identify the scheme as indirect taxation and collection at the source, because that's exactly what they did 32 years later We'll be back next week.